So they certainly are changing in uncertain times, but we know that being prepared can reduce anxieties and it brings us all together, and it brings us just some cohesiveness. So one of the things we want to do is getting our legal things in order, and especially today. So we want to discuss, these are things that we're going to discuss today that will go throughout the nation. So whether you're in California, which is where we are, or if you're in New York, some of what you're going to hear today is going to be very important to you wherever you live. And so we have with us a very well-known and wonderful elder law attorney from California. His name is William R. Remery. You will find him again in our Wellness Village, so you don't need to write all of this down. But William Remery is a California law legal attorney. And so welcome, Bill, and thank you so much for being here this morning.
Good morning. How are you doing?
Good, good. So in the years that you've practiced law, obviously you've seen a lot of changes, but you haven't seen anything quite as big as this. And so we're here today to try and tell people things that they should know today, that they should know right now. What are some of the things that you think should be in place right now, particularly because of coronavirus?
Well, particularly because of the virus, but I've been harping on this, as you know, doing the support groups and stuff now for years, is that everyone should have two simple documents at least: an advanced healthcare directive and a durable power of attorney for finance. Those two simple documents solve so many problems when people are trying to help you, or if you're requesting help from other people. But for those documents, they're relegated to going to court and getting all these kinds of assistance from the judges, which of course the courts are closed right now. So adding even another layer of problems where these two simple documents can cure many of those problems. Now, if you don't already have one, they're downloadable off the internet. California has statutory forms in the probate code. If you Google California durable power of attorney, you'll get a list. The first 5 or 6 are commercial sites, although they say they're free forms. They want you to sign in and do, put in a password and all that jazz. Skip down past those. Go down to the first site or the second site that says PDF before the site. That's a downloadable form. It's fill in the blank. This is a California statutory form. Anyone can fill out California. New York may have a similar thing. I'm sure if they don't have a statutory form, they have a commonly accepted form there. Same thing for the advanced healthcare directive. Again, it's in the California probate code. It's pre-done form. You can download it off the internet, find a PDF version, and you don't have to sign up with anybody. You don't have to pay anything. Just download them, complete them. Now, having completed the two forms, the advanced healthcare directive is valid if you have 2 witnesses, or it can be notarized. You do not need both. The financial power of attorney, while technically valid even without being notarized, will generally not be recognized by a bank if it's not notarized. So for all intents and purposes, that would ought to be notarized as well. And with any document, if it has to deal with real estate, it must be notarized anyway. So since you're going to have a notary out there, you can have them do the advanced healthcare directive at the same time.
Which is today in essential businesses, probably the one that we're going to find open is going to be perhaps a real estate company versus a notary.
I would contact a mobile notary. We have a mobile notary here that we're using at the office. Sending out to clients' homes. Obviously, you'll use the social distancing precautions of staying 6 feet away, and you can obviously everyone will be washing their hands and doing all that kind of stuff. But that is, I think, the least intrusive, the most responsible way of doing it right now is have someone come to you and have this done.
A mobile notary.
Mobile notary, yes. You could go to, again, a Kinko's somewhere that some of these businesses may be open. I don't know. But I think the best way to go about it would be with a mobile notary.
Okay. So those are 2 documents: durable power of attorney for healthcare or durable power of attorney for finance. Did you say both? And then also the medical directive. That's actually 3.
I'm sorry, Joe. We got interrupted there. Could you say it again?
Okay, so I think you talked three documents: the medical durable power of attorney for healthcare, the durable power of attorney for finance, and the medical directive. Am I correct?
Okay, now in California, we have a combined durable power. The two documents are combined into one. We used to separate them out. We had the Natural Death Act for the Advance Directive, and then we had the Power of Attorney Act under the Probate Code. They've been consolidated in the Probate Code as one document. Other states may have two separate documents. The Durable Power of Attorney for technically is a simply nominating a person to make decisions for you. That's what a power of attorney is. You're designating someone else to stand in your shoes. And then the second document is one where you express your desires as to what you would want under various medical contingencies. In California, we combine the two. We nominate the person to make the decision, and then we give guidance to that person.
Terrific.
The
okay.
second half of that is optional. If people don't want to think about it or don't want to take the time to do it, at least nominate the person to make your decisions. But if you do not specify what you would want in end-of-life decisions and things like that, then you should certainly have the conversation with your agent, because your agent is the one who will be making those decisions and speaking with your physician.
Okay. Good. This is really good information. So down the line, people probably want to know more about these three topics or these two topics. And for the information of our listening audience, eventually will get into some lecture series, but this today is just to bring resources to you as quickly as we can with tidbits of things you should know today. So let's go forward. The POLST form, Bill, you didn't allude to that particularly because is the POLST form a United States form, or is that a California form?
I believe all of the states have adopted. Each of the states have their own twist on it. In California, we have our own form. It's called it's on Pulsar pink paper. This very vibrant pink paper, so that everybody can see it if it's in your medical record. It is I'll call it a supplement to the Advanced Healthcare Directive. With the Advanced Healthcare Directive, your agent will make decisions about ongoing life support, cardiopulmonary resuscitation, artificial nutrition, all those things. Instead, you go to your physician.
They're playing tag with each other because ours is ringing than yours.
I have people lined up to call me because they have these similar questions. So yeah. I'm fending off their calls till we finish up here. Okay. Then I have to start taking some of those.
Okay.
Because so
POLST stands for
a physician's order for life-sustaining treatment, POLST. And what that is you actually have to meet with your physician, and that may be a challenge right now unless you have a current cold or something that you need to meet with a physician. But you meet with the physician, review with the physician your options under different scenarios. For example, would you want CPR if you went into cardiac arrest? Yes or no. You can say yes on the POLST form or no. Would you want artificial nutrition or hydration if you were in a situation where you couldn't eat or drink? Perhaps you would want it all the time. Yes, keep me alive as long as possible. Or no, I never want it. Or go ahead and try it for a little while and see if I get better. Those are options on the POLST form. Once the physician fills that out and signs that form, it takes it out of the hands of your agent now under the Advanced Healthcare Directive, because that becomes a physician's order. No one needs to call your agent. No one needs to call the paramedics or anything. You actually have a physician's order on file. So it serves somewhat different purpose. We usually use that where someone is on hospice or perhaps in a long-term care facility where the decision is pretty much already made. Treatment.
But today we may even skip hospice, and we skip some of this stuff because people are going directly into the hospital when they have have COVID-19. So these are things, again, to prepare, or things you should know right now. Get them done if you can. And if you need to get in touch with Bill Remery, You will do it through our website, going to the Wellness Village. You look under Elder Law and you'll find him. Two more things kind of briefly, Bill. Is this a time probably that somebody, if they don't have a legally drawn will, should they be considering putting together a holographic will, something that tells the world what it is that they want to do with their with what they may have left?
It certainly doesn't hurt. It will do exactly what you said. It will, if someone were to die, it will say, you know, who should receive the estate and what proportions and whatnot. With more time, or perhaps using through the internet or using this Zoom technology, having an interview with an attorney, you can actually develop a full estate plan with a trust and everything. And in fact, if we're home and we're not doing much right now, maybe this is the time to put your thoughts together and you can actually take care of some of that paperwork stuff. The execution of it, again, probably with a mobile notary, but except for that little piece of it, it's a good time to sit back and kind of inventory your legal documents and get your affairs in order. One particular concern that I have, having run into this numerous times in the 40 years I've been doing this, is with general estate plans. We have adult children, we're later on in life. If we don't have our estate in order, you know what? The default is it's going to end up going to court. There'll be a probate. It's going to take some time. It's a little more expensive, but things will get done. But where things come up that are I think are much more immediate is if you have minor children. If you have minor children, you can't afford the time, the delay, the expense to go to court to set up guardianships and things like that right now. So the two documents that I would lobby with anyone who has minor children to have in place is, number one, nominate a guardian. Nominate someone to take over for you if you or the other parent is not available to take care of your child. Number two, have some kind of an estate plan in place, hopefully a formal trust. If not a formal trust, then informally having your assets go to a trusted person by beneficiary designation if necessary. Somehow give them access to the resources they will need to take care of your child if you're not able to.
Oh, God, Bill, that is absolutely, I am so glad you touched on that. There's so much more that we need to touch on too. So hang around, stay tuned. We'll get you back probably to do an entire lecture down the line. We'll call you in when we do our online support groups, which we're gearing up to do as we speak. And I'm so grateful that you're out there to help us and to help ever so many people. You're a star in my view, but you've always been. So thank you, thank you, thank you. Is there anything you want to add?
No, again, contact someone local to you. A lot of the attorneys are out there with virtual offices. I know my daughter is working from home. We're connecting virtually. There are resources out there. Take advantage of this extra time that you have. Think about things a little bit and see if we can help you.
So grateful. Thank you so much, Bill. We'll be talking to you by phone or by Zoom really soon.
Real good. Take care now.